for today's meeting with the Connecticut Paid Leave Authority. The seminar or the webinar is hosted by the Greater Valley Chamber of Commerce, the Bridgeport Regional Business Council, and the Fairfield Chamber of Commerce. Unfortunately, Bill Purcell, the president of the Greater Valley Chamber, has had some technical issues, so they asked me to introduce Andrea. Unfortunately, Andrea, I don't have any information, so I'll just hand it off to you if you don't mind.
All right, that's fine. Thank you very much, Walter. And thank you everyone for being here this afternoon. We do appreciate the opportunity to speak with you about paid family and medical leave. As Walter and I were chatting earlier before we began, it is a complex law. In its shortened version, it is 49 pages long. In its longer version, it's much more extensive. So we appreciate the chance to be able to explain it and field any questions that you might have. With me today is my colleague, Amber Forrest. Amber will be working to answer some of the questions. We ask that you use the Q&A feature to submit your questions so that we may answer them on behalf of the entire audience and attendees. In addition, she will use the chat feature to provide links to information that may be of value to you or in direct response to a question. So Amber, just say hello to all the folks and we will get going.
Hi, everyone. Thanks so much for joining us on this Friday, TGIF. We have the Q&A feature open on the bottom of your screen. So if you have any questions during the webinar, please submit those questions using the Q&A feature on the bottom. In the meantime, I'll be using the chat to drop different links on different topics that we're discussing, as well as useful resources and tools. Thank you so much for being here today.
Thank you. And I see that Mr. Purcell has joined us, so perhaps we'll take a moment to hear his greetings and then we'll get started. You're on mute. And there we go.
Well, thank you so much. And I'm a little embarrassed. We were having a little technical difficulties, and we're coming off a major program this morning, Andrea, focused on the Valley's response to the COVID-19 pandemic. We had a very distinguished panel, including the president of our community hospital, Pat Charmel, who did an extraordinary job. As we were trying to get in, I heard my dear friend Walter Murphy for my benefits. And thank you, Walter, for conceiving of this seminar today and for connecting us with Andrea's good offices. I'm so pleased too, as well, for your benefit, Andrea. You know, I just want to say state government has been so open over these past 9 months, from the governor to the commissioner of the ECD to commissioner of labor, working through the chambers to impart vital information like we're going to do today as well. But I just want to say a couple of words. I did have an opportunity to view the press conference back on January 23rd, announcing your appointment. I just want to share, for the benefit of our audience, a couple of words that were shared that day. Lieutenant Governor Bicewicz had this to say: Andrea Barton-Reeves brings extensive experience in all the fields that are critical to the efficient administration of this important program, from legal, insurance, and healthcare expertise. And as a nonprofit leader, she brings compassionate understanding of the needs of families. Josh Gabel, it's always nice to hear from the chairman of your board, right? Who had this to say: Andrea combines extensive nonprofit and private sector leadership and operational experience with a commitment to public service and an understanding of the needs of the underserved and underrepresented. So prior to your appointment, I know you had a wonderful career at Hark Inc., a nonprofit leader, providing support to people with disabilities, intellectual and related disabilities. You're a lawyer by background with a degree from New York Law School. We just want to welcome you to the administration and thank you for being with us today. So with that, the screen is yours, Andrea.
Thank you very much. I appreciate those very kind words. It was almost a year ago, it seems, and quite a year it's been. So we'll have an opportunity, though, today to look forward to the future and see what we can offer. We'll share my screen. Let's see. All right. Amber, will you let me know that it's visible?
Yes, ma'am, you're good to go.
Thank you. Let me then. All right, and then let me, let's see. Come on, there you go. All right. Still not quite. Hang on a second for me. There we go. All right, I don't want to be a distraction, so I tend to turn that off. And here we go. All right. So thank you for giving me some time this morning to review our presentation on understanding the Connecticut Paid Leave Act. Oh, come now. Now I'm having technical difficulties. Here we go. All right, now, as was mentioned earlier, I've held this role since March 2nd. I did come from HARC, where I was the CEO and spent 10 years there, first as its in-house counsel and then as the CEO, supporting people with intellectual disabilities and their families. I do have a long and abiding commitment to public service. It is essentially what I believe that I'm here to do. I have an undergraduate degree from Rutgers University in English and a degree in law from New York Law School. So today, our agenda will include an overview of the paid leave program, key dates that you should be aware of, and an overview of the laws themselves. We'll explain how to apply for benefits and the way in which that will work through our program, the role of the employer, and putting some of these laws into practice, some additional resources that are available to you as employers for your employees and for yourselves, and then questions and answers. The Paid Leave Authority itself has a twofold mission. We're here to provide pathways to accessible paid leave benefits for families in the Connecticut workforce. And we're also here to empower employers and administrators and healthcare providers by offering them tools so that they can understand the program and their role in it, and to help them navigate the statute and the program itself. We have 5 primary responsibilities at the Paid Leave Authority. They are outreach and engagement, and developing the policies and procedures that are needed to run the program. We also establish this trust fund contribution rate, which by statute is 0.5%, and we receive contributions to that fund. We are responsible for approving and auditing private plans, and finally, we administer claims for paid leave benefits. So who is covered by this law and this plan? Covered employers include those that have 1 or more people working in the state of Connecticut, including not-for-profit organizations and private sector employers that have unionized workforces. Sole proprietors and self-employed individuals who choose to opt into the plan may do so at any time, but when they do, they must remain in for a minimum of 3 years. Those employers who are not covered by the Family Medical Leave Law include the federal government and state employees, with the exception of covered public employees. The same is true for municipalities and local or regional boards of education, unless they too have covered public employees. The one category of employer that is completely exempt are non-public elementary or secondary schools. So what exactly is a covered public employee, since there are exceptions carved out for them in the 3 instances that I outlined? They are, with respect to the state of Connecticut, the non-unionized employees of the state. They may also include those unionized employees who collectively bargain to be included in the program. Employees of municipalities and local or regional boards of education may also be included if the unionized employees of the municipalities and the boards of ed collectively bargain to be included. If that is the case, then all of the employees in the municipality and all of the employees in the local or regional board of ed will be included in the program, whether they are in the union or not. You can see here that there is a fairly expansive definition of municipality, which runs from our traditional understanding of a town or a city all the way through to a flood commission or a regional council of government. Contributions will be collected starting January of 2021, so only a few weeks away. And what happens to those? The employee contribution of 0.5% of wages is collected by the employer through a payroll withholding. The employer then remits those contributions and their wage information to the Paid Leave Authority. We receive that information and we validate it through information that's available to us from the Department of Revenue Services and the Department of Labor. The contributions are deposited into the Paid Leave Trust Fund, which is managed by the Office of the Treasurer. Then the Paid Leave Trust Fund is used for the administration of the program and to pay paid leave benefits. Here are some key dates that are important to know. Our website launched on September 4th of 2020. It has an abundance of information that is available to you, employees, employers, third-party administrators, self-employed, individuals, sole proprietors, and healthcare providers to learn more about paid leave. We're asking all employers to register now by going to ctpaidleave.org. Sole proprietors and self-employed individuals who want to be in the program may do so now, but they may register at any time. Employers will begin deducting the contributions, the 1/2 of 1%, starting in January of 2021, and then benefits will be available starting in January of 2022. Now let's go through the leave laws themselves, starting with an overview of the reasons for leave. Under the statute, leave can be taken to create or expand your family through birth, adoption, or foster care. You may also take leave to care for a family member with a serious health condition or to attend to your own serious health condition, which can include serving as an organ or bone marrow donor or pregnancy. There is special leave that is available to care for a family member who has been injured in the military. There's also qualifying exigency leave so that a family member who is being deployed overseas can be supported and seen off by their family. And what is unique to Connecticut's law is that family violence leave is available for up to 12 days of paid leave so that those who are impacted by family violence may take time to care for themselves without lost income. Let's compare what our law looks like now versus what it will look like in 2022. So to the left of the screen, you can see the outline of the primary factors of our current law. It applies to large employers, those with 75 employees or more. And for those employees to have access to family leave benefits, they have to have worked at least 12 months for their employer and 1,000 hours immediately preceding the time that they're taking their leave. And if they do so, then they are eligible for job protection after having worked for the employer for 12 months. After having done so, 16 weeks of leave is available in a 24-month period, and the employer can require the employee to exhaust all of their accrued time to cover all or part of the time that they're away for leave. This changes considerably in 2022. The threshold for applicability to employers lowers from 75 to 1. There is no hours worked requirement, and job protection is available to employees after 3 months of work as opposed to 12. 12 weeks of leave is available in a 12-month period, with a few exceptions. That meaning that there are 26 weeks of leave available for military caregiver leave, with 12 of those being paid, and there may be an additional 2 weeks of leave available for incapacitation experienced during pregnancy. The final important difference between our current law and the new one will be that employers can still require their employees to use their accrued time off to cover part or all of their time, but they must allow the employee to keep up to 2 weeks of their accrued vacation or PTO leave. So looking at the array of laws that are available for job protection, many of them, all of them remain in place. So federal FMLA remains as it is. Connecticut FMLA will change to provide job protection for employers with 1 or more employees after 3 months of of service. Workers' compensation, the Americans with Disabilities Act, Pregnancy Disabilities Act, and the Connecticut Fair Employment Practice Act will all remain standing laws in the state. Income replacement will now include workers' compensation and Connecticut paid leave as of 1/1/2022. I've outlined the differences between the laws regarding our current state law and the new one, but another important difference to take into consideration is the difference between the federal FMLA and its definition of family and what our state's definition of family will be under the law when it changes a year from now. Under the Connecticut law, an employee will be able to take leave and receive paid benefits to care for a much more expansive number of people in their family, including a parent and a spouse, a son or a daughter of any age, a sibling, a grandparent or grandchild, or those to whom they have a relationship or a close association that is the equivalent of those family relationships. And you can see here the age requirement for leave to take care of a child is eliminated under the new Connecticut law, and that child no longer has to have a disability in order for you to be able to take care of them if they're over 18. So what exactly is related by affinity? The definition that has been adopted by the Board of Directors of the Paid Leave Authority is that first sentence. It's any person with whom the employee has a significant personal bond that's like a family relationship, regardless of their biological or legal relationship. Perhaps the example that we can relate to most closely is the bullet that is second from the bottom, where there is an unmarried significant other of the employee with whom they may live and have a familial spouse-like relationship, but they may not have a legal relationship to one another. In those instances, that employee may want to take time to care for the person who they consider to be a spouse, which is not something that's available under our current law, but will be when the law starts in 2022. What is the length of the benefits? Federal remains the same, 12 weeks in a 12-month period, up to 26 weeks for military caregiver leave, and the same will be true for our FMLA in 2022, with the additional 2 weeks available for incapacitation during pregnancy and 12 days for family violence leave. Those same amounts of leave and the time will also be available under the paid leave benefits that can be available and accessible to employees. The eligibility requirements are outlined here. Federal remains as it is. 12 months with the employer, 1,250 hours worth of work. Job protected leave under our new law will be available to employees at 3 months, and there will be no hours worked requirement. To access paid leave benefits, the person would have had to have earned at least $2,325 in what we call the base period. And the base period is defined as the highest earning quarter of the past 4 of the 5 quarters. And that can be earned from 1 or more employees. In addition to that, they have to be currently employed and working in the state. They had to have been employed and working in the previous 12 weeks immediately preceding the time they applied for leave, or they're a sole proprietor or self-employed individual who's opted into the program. In addition to that, eligibility must meet one of the reasons for leave that's outlined in the statute. Let's talk about the role of the employer. We ask every employer who has an employee coming to them asking for potentially FMLA qualifying leave to ask themselves 2 questions. First, is the employee eligible for job protected leave under 1 or more statutes? And is that employee eligible for income replacement while on leave? It's important to ask both questions because it will impact the answer that you give to the employee and the types of leave for which they may be eligible. We know that employees can be eligible for federal FMLA only, state FMLA, both running concurrently, neither, but perhaps a job protected leave is a reasonable accommodation, perhaps under the Americans with Disabilities Act, or no job protected leave at all. We've reviewed here some of the federal and state qualifications for eligibility. These should be criteria that are also applied to a request for leave. Here are some facts about the income replacement. What about benefits coordination? So employees can receive benefits from both the authority and their employer provided benefits at the same time, but those combined benefits can never exceed 100% of the employee's regular wages. Some short-term and long-term disabilities require that employees exhaust state-provided benefits first before they can access benefits under short-term or long-term disability policies. And that's fine. The employees can, in fact, come to the authority first. But employees may not collect workers' compensation and paid leave benefits at the same time. Here's an important point that employers should know. An employee may be eligible to receive benefits from the paid leave authority, but they might not be eligible for job protected leave. And here's how that might work. The statute, as I noted earlier, allows for paid leave if a person has earned the $2,325 in that base period, they have a qualifying reason for leave, and they've met the amount of time that they need to work, which are the 12 weeks, either currently working or had worked 12 weeks prior to the time they applied to leave. You may have an employee come to you in their first month of employment, having met those criteria, but not having worked with you long enough to have job protected leave. In those instances, they could come to the authority and apply for wage replacement while they're away. But we're strongly encouraging every employee to have the conversation with their employer if they've worked for fewer than 3 months to make sure that they have a job to come back to. But as an employer, you should know that this scenario is possible. Then let's talk a bit about private plans, which I'll do in more detail in a moment. But if an employer is offering a private plan, They are managing all of this themselves within the purview of their private plan. The paid leave authority has only a role in approving the private plan, and the employer is administering the plan, including the payment of benefits and determining eligibility. So returning a bit to the required use of accrued time, employers may require employees to use their sick accruals, their vacation, their personal leave, and other PTO to cover all or part of the time, as long as they are entitled to keep up to 2 weeks of leave. For employers that have an unlimited PTO policy, you will then have to reconsider how that policy will be applied in this context. So how do employees apply for benefits to the paid leave authority? The first thing they do is come to you and submit their application as an employer for leave. They get their leave approved, and then the employer will tell them whether or not they have available time off and what your requirements are for the exhaustion of their sick time and a possible application of additional vacation time, holding back those 2 weeks to provide some form of income replacement while they are away. Once that discussion has been had, it is the employee's responsibility to apply to the paid leave authority for benefits. We then have a 2-part process in the beginning where we validate eligibility, and we also validate the reason that the employee is seeking benefits. We calculate the benefit amount, and then we continue our due diligence by validating the employee's actual covered absences with the employer, and we calculate any offsets that the employee may have based on employer provided paid time off, and then we issue the benefits payments. Those payments look like this. The statute has a 2-part formula. For those who are earning less than or equal to the minimum wage multiplied by 40, their weekly benefit is 95% of their covered employee's base weekly earnings. 2020 minimum wage is $12, so the maximum benefit at 95% is $456. If you make more than that, more than the 480, then it's a bit more complicated formula. So I have a couple of examples. So here's Mike. Mike makes $375 a week, which is less than the minimum wage multiplied by 40, which we know is 480. His benefit is going to be 95% of the 375, which is 356.25. Deborah makes considerably more. So we start figuring out Deborah's wage replacement by starting with the 40 times the minimum wage. So we know she'll get at least $480. Then we take what she's earning and we subtract that amount. And that gives us the difference that we will then multiply by 60% to figure out what her total amount is. So here you can see it's 480 plus 132. She will get $612 in weekly wage replacement benefits. How does paid leave actually work in the workplace? So let's look at a couple of examples. We have Mr. Coyote, who has worked for a large employer for 10 years. He has 4 weeks of sick leave and 2 weeks of vacation time, and he's hurt his hand in a non-work related fireworks accident and needs to be out for 8 weeks. We apply that 2-part analysis. Job protected leave, yes or no? Income replacement benefits, yes or no? And here's what his circumstance looks like. 10 years of employment means that he's eligible for both Connecticut FMLA, having well exceeded the 3 months, and federal FMLA, having well exceeded the 1 year of employment and the hours worked requirement. Because he has enough sick leave to cover at least the first 4 weeks of his time, he is required to exhaust that, but not his vacation time. And then he will come to the paid leave authority to receive wage replacement for the remainder of his time he is away. Jamie works for a smaller employer and she works part-time. This law does apply to all employees, full or part-time. She's worked there for 2 years. She has six days of sick leave and 3 weeks of vacation time, and she has injured herself running with her dog. Again, we apply the 2-part analysis of job protected leave and income replacement. And for Jamie, her circumstance looks like this. She is eligible for job protected leave because she's worked well beyond the 3 months for which she would be eligible. She has no FMLA leave because she has not worked the requisite number of hours to be eligible for FMLA. She can be required to use her sick leave accruals and a portion of her vacation so that she can hold the remaining 2 weeks, and she will go to the paid leave authority for wage replacement for the remainder of the time she will be out on medical leave. For employers who have spouses who work for the same employer, under federal and state, those spouses have to share their job protected leave time to bond with a newborn child. Under federal, they have to share it to care for a parent with a serious health condition. Under state, they have to share it to care for a family member with a serious health condition. Come 2022, spouses will not be required to share their paid leave benefit entitlement for any reason. Let me speak a bit about private plans. Statute allows for employers to offer private plans as an alternative to the public plan, but that can be done only if several criteria are met, and they are these. The plan must offer the same or better benefits as the public plan, and it can't cost employees any more than the public plan does, and those contributions, if collected, must be limited to 0.5%. If the paid leave authority lowers its contribution rate, then private plans must follow suit. It must demonstrate the ability to administer claims and benefits, and statutorily, the employer must hold a vote seeking the employee's approval of the private plan option, and that vote has to be held with the majority of all of the employees that work in the state, and then they must vote in favor of or against the private plan. A short-term disability policy will not meet these criteria because it does not have a contribution, and it also does not require a vote. Finally, the paid leave authority must approve the plan. Your approval is good for 3 years. So if an employer is interested in offering a private plan, there are 3 steps. First, when you register, please simply indicate whether or not you plan to apply for a private plan. This is not an obligation in any way. It's just an indicator so that we can understand how many employers are actually contemplating a private plan. Soon, you will receive an email and you'll be asked to go back and complete an application for the plan. Then once you've completed that application, you will upload some final documents, and those documents will be a declaration from an insurance company that has indicated that it will offer insurance in this space in the state. Something we're calling a plain language guide, which we've created for you at the Paid Leave Authority, that is a summary of the statute in plain language for you to share with your employees. And finally, proof of your vote. Once you have submitted those documents, we will then make sure that your final plan documents are consistent and inform you of your decision. As I said earlier, your approval is good for 3 years, subject to a periodic review to make sure there are no substantial changes that may require that the plan be resubmitted to employees for a vote. I said a lot today, and it's a lot to take in. We will share this presentation so that it can be distributed, but there's also an enormous amount of information that's available on our website at ctpaidleave.org. There you will find these documents along with videos and frequently asked questions. On this, I've just summarized for you some of the most pertinent and salient documents that might be helpful to you right now. There is an employee rights poster that summarizes everything that I spoke of with respect to benefits, availability, and eligibility, the amount of wages that will be collected, and when benefits will be available. That is available in a more abbreviated form than the employee rack card. There's also an employee fact sheet that can be downloaded and emailed to employees, which is true for all of the documents on this screen. Finally, you'll see something at the bottom of the screen right below the employer toolkit that we call the paycheck mailer. This is the most downloaded document on our site. You can download this and email it to your entire employee workforce, and to let them know that their paychecks will be changing in January. Everything that I've spoken of is available in the employer toolkit, which is a 24-page comprehensive kit that has every single thing that I've mentioned today. So we're calling employers to action by asking that they do a few things. First is to register by the end of the year. And this is so that we know that you have a contribution withholding obligation that starts on January 1. If you use a payroll provider or any other third-party administrator, to support you in payroll or other benefits, make sure you talk with them to know that they're ready. We have had extensive conversations with virtually every large payroll provider, so they should know. And if they don't, please let us know because we'll have a conversation with them. Educate your employees about withholding by using the information and the documents that I outlined in the slide immediately preceding this one. And visit the website regularly for updates. We're here to help you. The best way to reach us is to use the Contact Us feature on the website, which will allow you to enter your specific question and ask us for any information. There are also more than 150 frequently asked questions that are in categories that you can find on the site, and there are also helpful videos. Everything on the site is available in English and Spanish, including all of the documents that I've outlined today. And I want to thank you for your time. Stop sharing my screen and come back on camera and answer any questions that you might have. Okay. All right. So thank you, Walter and Bill, for that opportunity to address your questions and to speak to your audience. Now, Amber, let's see what we have in terms of the Q&A, and see what I can answer in the time we have today.
Okay, great. Thank you, Andrea. So I've been answering a few of the questions in our Q&A here. The one that we have right now is, why every employee isn't included in the plan? Why isn't the program voluntary?
Okay. So the program is not voluntary, and the only answer that I have for you is that that was part of the negotiations that were entered into in order to create the statute as it is. For every state that has a paid leave program, it is not voluntary. So it is a withholding so that benefits can be made available to as many employees as possible. We're well aware, and we have a very vocal constituency in our state, and we're very grateful for that have let us know that voluntary participation would probably be a better option. But as the statute currently reads, that is not the way that the program works.
Okay. Are private sector employees with non-union workforces covered?
Yes, they are.
For clarification, is it correct that self-employed businesses, for example, consultants, who are paid by 1099s do not have to apply? Is there anything they need to do to opt out?
So that is correct. If you receive a 1099, you do not have to apply. You may opt in, and there isn't anything that you need to do to opt in or opt out. You just simply wait until you make a determination as to whether or not you want to participate, or you might not ever make that determination. There's nothing that you have to do.
How about LLCs that are classified as an S Corp? The owner is an employee.
Yes,
Must they register and pay the 5%?
So that's an interesting question that just came up this morning. Technically, if you receive a W-2, and this is the guidance that we've also received from the Department of Labor, you are an employee and you're covered under the expansive definition of the statute, and you should be contributing the 0.5%. We do know, however, that some S Corps decide to use that treatment so for tax purposes and for other reasons, and that they would necessarily be a sole proprietor or self-employed individual were that not the definition. Let me put it this way: how they operate practically might be different from how they are defined legally. So what I'm going to do, because we still need to get one more answer from the Attorney General, is ask if I can get back to you on that, because we're just finalizing that right now. Yeah, because that's a question that we, quite frankly, and the law is not clear on it.
What if someone works for a Massachusetts employer and lives in Connecticut? Normally, the employee commutes to Mass every day. However, the employee is not working from home in Connecticut. Is the employee eligible?
So from the way that the scenario was described, the person is actually working in Massachusetts and lives in Connecticut.
Yes.
So they would not be contributing to the fund, nor would they be eligible for benefits. So with respect to employees, sole proprietors, well, I'll just say for employees, there's not a residency requirement. The focus is on where you work, not necessarily where you live.
We're a small company, 10 people, not all full-time. We have to protect everyone's job for 3 months and find a temporary replacement while they are out on leave. Please confirm.
Yes, that is true. You do. And I understand that this is a significant issue for small businesses. We absolutely understand that. Here's the thing, though, that regardless of the size of your business, if you do have to bring someone in and they work for that person because they have job protection, you are held harmless with respect to any unemployment obligation that you have, because that unemployment obligation is pooled and you will not be charged for it, and you won't have any adverse impact on your unemployment obligation as a result of that.
What is the form name that we need to file with payroll tax return? And is it filed on a monthly or quarterly basis?
Okay. So we don't have a form for us for the payroll tax return. So I'm not, I hate when I don't have an answer for all the questions, but we don't necessarily have that. The way that remittance of the payroll tax will work is in two parts. You're withholding now, and we are working with the major payroll providers to make sure that there is a box that you can include on the paycheck that would indicate the 0.5% withholding, so that that's transparent to your employees. That's part one. And then the wage withholding comes quarterly. So it will be due the last day of the month following the end of the quarter. And with those contributions, you will also give us wage information. And that will be done by your third-party administrator. If you're doing it yourself, you just send us a form that says, I've got, these 25 employees, and here's 0.5%, and then we verify that, and we verify that with the Department of Labor. So there's no specific form that you'll need to fill out. You can give us an Excel spreadsheet. We're not trying to make this harder for people.
Thank you, Andrea. Are employers supposed to enter during the registration process the payroll company they use, or the payroll company has already registered as a TPA?
Okay. Yes, it's a great question because it can be a little confusing. We're asking employers themselves to register. Some employers use a TPA for their payroll and benefits work. Some of those TPAs have been asked by their clients to register on their behalf. So the large ones, like Paychex, I know is one of them. I think ADP is considering it. Those large payroll providers have said to us, one has said yes, the other is still deciding, we'll register on behalf of the employee, of the employer. So we have a path for them to go in and essentially show up as if they were you as the employer, register on your behalf, and then you don't have to do that. But I would verify that with your payroll provider. If they are not going to do that for you, then you do have to go in and register yourself. Then your TPA will also register, because we need to know that they're going to be providing the withholding and the wage information on your behalf. And then some of them, all of them essentially, are employers themselves, and they will be registering in their own right as an employer.
Thank you, Andrea. And can you just touch base again, as a sole proprietor, how is the 0.5% calculated and submitted, particularly if you have fluctuating income?
Yes, that's an excellent question. So we're actually working on a formula and some guidance for you right now for those of your sole proprietors. So we understand that the statute says you remit quarterly, but that doesn't always work when you're a sole proprietor. So it may be that you will make payments on an estimated basis, and if you overpay, then we will credit you for the following year or subsequent years. Or when you do know we have more certainty around the time and the amount that you will be making, then you may make those payments going forward or retroactively. We are almost done figuring this out, I promise you. We are almost, we've heard very loudly and clearly from sole proprietors and self-employed, this cadence does not work for us. And so I was literally on the phone with one of the chairs of the labor committee last night saying, I need your help. I'm not sure you necessarily contemplated this. This is how far we've gotten with it with the Department of Labor and Department of Revenue Services. We just need one more step. So almost there, just hang on. We will be issuing some guidance around that.
Great, thank you. And what are the record keeping requirements for an employer in regards to employees using Connecticut paid leave?
Okay, so the use of paid leave is something that we will be tracking on our site. So I want to make sure that there's a distinction between the paid leave and family medical leave, especially for small employers who have not had any interaction with family and medical leave at all. So the person comes to you, they submit their application, which is essentially a certification from a healthcare provider that this person qualifies for leave. Let's just start there. So that's why we have that two-part analysis: job protected leave, income replacement. So the person comes to you and says, I need 3 weeks of leave because I have to have some surgery and I need to recover. You are then tracking, they're going out on date 1, they're coming back on, they're leaving on date A, they're coming back on date B. That's your responsibility as the employer. On the paid leave authority side, we're determining the same thing. They're going out on date A, they're coming back on date B, and they will be subject to, they will be eligible for wage replacement during the time that they're out. You're not tracking the wage replacement benefits that we're paying, we're doing that.
Great. Thank you, Andrea.
Okay. But one more thing around that, Amber. We are our plan is to communicate regularly with the employer, so we make sure that those two dates align. So if you've got someone who's supposed to be back on date B and they're not showing up until months later, that's not what we're trying to do. Okay, so we're going to be, you said you need to be back at this time, and then there'll be an opportunity for us to check back with the employer to say, have they returned? Because our records say that their leave has ended and we're no longer paying benefits. If they haven't returned, then we want to know that to see if we can support you in any way, because they should be returning to work.
Can you start out withholding from employees and switch to a private plan in 2021?
Yes, as a matter of fact, we encourage employers that if you have not made a decision as to whether or not you're going to have a private plan, withhold now. And the reason is this, that your ability under the Department of Labor rules to go back and collect any money from employees, should they either decide not to vote for a private plan, or for some reason you as the employer decide not to create one, will be substantial. So we don't want employers to ever be in that circumstance. So hold it aside. When you finally make a decision, then you either use it for the administration and the payment of benefits for your private plan, or you submit it to the state for the public plan. But do not get yourself in a really tough financial situation by failing to withhold until a decision is made.
Thank you. So the next question, this is actually one we were just discussing yesterday. It says, I understand you only enact what the legislature has enacted, but what is the reason for not leveraging DRS existing payroll tax system? We could have added a new line to that system the same way new sales taxes are added. Why did we create an entire new system?
Yeah, that's an excellent question. And here's the reason why. The Department of Revenue Services was well ahead of us in what they had created. So we did have conversations with the Department of Revenue Services to ask whether or not there could be some way that we can work more, cooperatively or collaboratively, so that it could be collected in one place. It wasn't possible. They were well ahead of what they were doing. And in order for us to meet our statutory deadlines, we had to make the decision to go forward with a separate system. So we hear you. We know that. We understood it from the beginning. We made our best efforts, but the alignment of time just wasn't one that made it possible.
Thank you. Okay, so we just want to touch base on this one because we actually have a lot of questions asking the same thing.
Okay.
So is it required for all employees to withhold from their paychecks for every company in Connecticut?
Yes. So unless you're within the categories of employers that were specifically exempted that I noted earlier, the answer is yes. Every other employer is included.
And could you touch base again one more time on why employees are required to participate in the contributions?
Okay. So they're required to, and it seems like it's probably not an adequate explanation, but it is the explanation that exists, because that is the way that the statute was designed. In order for there to be enough resources to pay for everyone who would that would access benefits, I don't want to say take advantage, but access benefits, the way that it needs to be funded is for every employee to participate in it. And that is based on actuarial analyses that were not just done for the state of Connecticut, but if you go to Washington State, Oregon, California, Hawaii, every state that either has temporary disability or paid leave, employees contribute. Some states have both employer and employee contribution. We do not. We have solely employee contribution. So in order for it to work and be available for all employees, then all employees need to participate in it.
you, Andrea. Let's see. Okay, I think we've answered this one already, but I'm just going to run it by real quick. So I am an LLC and I am the only employee right now. If I do not opt in before January 2020, can I register later, for example, June of 2021 or February of 2022?
You can register later. So I'm assuming that that person's really more like a sole proprietor or a self-employed person. And if that is the case, so I was self-employed when I had a law practice, but I was an LLC for tax and liability purposes. So I would have been considered, I was the only person and the like. So that under this program, I would register when I felt I was ready to register, and I would opt in.
Thank you.
Mhm.
Okay. The status of the program, the status or the I'm trying to understand this question. Give me just a second.
Sure.
The status of the program is considered difficult for some small businesses.
Mhm.
Is there any funding available to help small businesses?
So not that I know of, and that's an excellent question. I can certainly bring that back. There's no funding available, but let me say this, that I and my team and I are acutely aware of how challenging this is for small employers. So we intend to, just as we are now, to offer as much training and support as possible for small employers so that you're not navigating this on your own. So that will include, at least in the first, we want it to be ready by February and maybe a little bit later, a series that's similar to the series that we've been doing this year, where we will teach small employers what family and medical leave is, what paid family and medical leave is. So it'll be very specific to small employers, including right before the call this started, we had our general counsel on the line. She's already working on a flow chart. What happens when Sally walks in your office and asks you for leave? What do you need to do? What form do you need to fill out? Where does she need to go? What can happen if you say no? What happens if you say yes? Because these are all of the questions that you didn't have to navigate before. Because if you didn't have 50 employees or 75 employees, then this wasn't a world in which you were in. But her name's Erin Choquette. So Erin and Erin essentially is the state's guru on family medical leave. I know employment law and family medical leave extraordinarily well myself, having studied it in law school and having practiced it a long time in the more practical application of running a large agency. The two of us know this law backwards and forwards. We know employment law, but we also know that with all of the experience that we have, it's complicated and difficult. And if we know it with large employers, we know it's even worse for small employers. So we're going to make this work. And the way that we're going to make it work is to train you and teach you as many times as we need to, over and over again, offer every episode. There'll be a small employer toolkit. There'll be this workflow that you can use. And we will be, again, like we were this year, on 75 webinars to teach you how paid leave works and how leave works, because we want to support you and make sure that you're successful in this, because we understand that it's different and difficult.
Thank you, Andrea. So some of the questions we're moving in now are a little more on private plans.
Okay.
Is there a voting form that an employer should be using for the employee vote? Yes.
Okay. So no,
Like, let me finish that.
Okay. No, there is no voting form. And here's why. Because employers have said to us very clearly, do not dictate to us the way in which this vote happens. Let us decide how it happens. There are ways in which we already have in place the way that we collect feedback from our employees around anything. Should the cafeteria offer salad? Whatever it happens to be. That actually happens to be a question that an employer that posed. So don't tell us how to do it. Just tell us what the criteria is. So the criteria is twofold. You have to hold the vote. It's statutory. And it needs to be anonymous. So we don't want to know, and you shouldn't know who voted for it and who didn't. Those are the two essential criteria. And then you have to give us those voting results, and they need to be auditable. So what does that mean? We have to be able to count the votes that were for and count the votes that were against. So whatever platform you use, papers, check marks, whatever ballots, whatever you use, just make sure that you can turn it over to us if we need to see it for any reason, so that we can count it ourselves. That's it. That's the whole criteria. There's no form.
Great, thank you. Okay. Do private plans offer advantages that are worth investigating?
Okay. So I can share with you the reasons that employers have told us that they're thinking about offering a private plan. The number one reason is benefits coordination. So if they're already offering short-term, long-term disability, some employers have sort of an employee, crisis fund. They have different things that they're offering, tuition reimbursement and the like. They would like this to be part of the array of benefits that they offer employees, and they want to manage that themselves. So that's the number one reason we hear. The second reason is, and I understand it's a reputation that state government has earned, we don't always quite get this right? So they don't really want to subject their employees to some of the experiences that they've had with state government. Understand that. We're working really hard to make sure that that's not the experience that you have. But if that's the choice that you would like to make as an employer, you can do that. The third is that some employers don't want their employees to have to go to the state for one benefit. This kind of goes back to the benefit coordination, and then come back to their employer for other things. And they'd like a little more control over knowing where that person is. Sort of that question that was answered earlier about, how do you know that they're going to come back? How do you know what kind of benefits they're getting? They'd rather have a little more transparency around that, so they'd rather manage that themselves. Those are the three reasons that employers have told us that they would contemplate a private plan.
Okay, great. Thank you. Okay. Could this paid leave replace a short-term disability program?
Well, I think that all depends on your short-term disability program. So if the question is whether or not you could send your employees to the paid leave authority for benefits and then not offer short-term disability, there are some employers that have been either contemplating that or contemplating a change in their benefits offerings to better complement paid leave. But I leave that to each employer to make that determination. In some instances, employers are saying that they will, some are contemplating changing the plan so that part of the benefit comes from short-term disability and part of the benefit comes from the paid leave authority. But that really depends on your plan.
Great, thank you. So this is another question that we get that needs a little bit of clarification. How would it work for a Connecticut resident who is an employee for a company outside of Connecticut?
Okay, so I think we answered a similar question, which is
Recently.
Right. Yes. But I want to make sure I understand it. So it's not about residency for employees. If you live here but work elsewhere, then you're not contributing, but you're also not going to be eligible for benefits. If the state in which you're working has a benefits program that's similar to this, Massachusetts is the most frequently is the most frequent example that people use. The people who work in Connecticut, but who live in Connecticut but work in Massachusetts, they're contributing to that plan, and then they are eligible to participate in that. But if you live here and you work elsewhere, you're not contributing and you're not participating. Okay.
Are there payment methods for employers to remit the quarterly costs?
There are payment methods, and I will say right now, they are all electronic. And that is because we are not sure when we're going to return to any physical space. So we don't want people sending us checks that are just sitting in a box somewhere. We don't want to be responsible for that and any compromising of your data. So that's, it will be, you can pay by credit card, you can pay by electronic funds transfer, you can pay by ACH, but it's all available. And we are working with Bank of America. So we're, it's not kind of the bank around the corner. It's going to be, a large established institution with which the state has a long-standing relationship. So I see Bill has reappeared, and I think that means that I'm getting the hook, and that's fine. So there's lots of questions, I know, but we're at the end of our hour, and I really appreciate the time that you've given me today.
And everyone, I'm going to drop a link in the chat to our Contact Us portal. So any of their questions that we were not able to get to today, please feel free to reach out to us on our Contact Us portal. Thank you so much.
Thank you. Congratulations, Andrea.
Oh, thank you very much. So it was my pleasure to be here today. Anything else we can do to support the small business community, we mean it, and please let us know. We'll continue to work with you.
I just say you are indeed a quick study. And you certainly demonstrated that today. I want to thank Dan Onofrio, once again, the president of the RBC, and Beverly, president of the Fairfield Chamber, and Walter, chair of our Chamber of Ambassadors. Rest assured, we will share this information, all of us, with our respective members. We'll get the message out far and wide. Thank you so much. Really
Thank
wonderful.
you. Happy holidays to everyone.
Same to you. Be
All right.
safe.
We'll
Be
see you in
well.
the next year. Thank you. Bye.
Thank you, everyone. Stay warm, stay safe.
Okay.